My name is Aneliya Angelova. I'm an immigration lawyer, and today we'll talk about fraud waivers, fraud or misrepresentation waivers. Well, what is a fraud waiver? In order to explain in a very simple and basic way, I'll give you the following scenario. Gabriela is from Romania and she's married to a United States citizen. They have been married for a few years. They were busy the first few years of their marriage and they never filed their immigration paperwork for Gabriela's green card. Well, the first question is, well, how did Gabriela come to the United States? She came as a J1 student. And she did not leave after her visa or after her authorized status expired, and she just stayed over. Okay, well, is that a problem for the marriage-based green card that Gabriela and her husband Michael are about to file? Well, the fact that she overstayed is not a problem itself, but we're talking about a fraud waiver, so I'm going to explain why a fraud waiver has to be filed in certain cases. It's called a misrepresentation or a fraud waiver. Well, what happens is Gabriela and Michael, they assemble all of the forms. They decide to do this everything by themselves. They Google all of the information and they file their paperwork, which is it's not rocket science to file all of the forms necessary for a marriage-based green card. So they file their paperwork, Gabriela gets fingerprinted, then she gets her green card, and then it's time for the best part, their green card interview. And they go to the local immigration office. Everything looks fine in terms of their marriage. They have lots of proof that they have been together for quite some time. They have pictures from different vacations. They have pictures from different holidays they spent together and pictures with Michael's family. So the officer approves the I-130 petition. The I-130 petition was filed by Michael, the U.S. citizen husband, and that petition establishes that Gabriela is his wife and therefore an immediate beneficiary, an immediate relative for purposes of the adjustment of status process. However, once the I-130 gets approved, the officer tells them that now he's going to move to the second application, which is Gabriela's green card application, the so-called adjustment of status application or form I-485. In that particular form, there are a lot of yes and no questions, and one of them is whether the applicant has ever procured or obtained an immigration benefit or tried to obtain an immigration benefit by material misrepresentation. And of course, most people don't even read these questions. They just answer yes, no, yes, no, yes, no. So Gabriela answered no. Now, the interviewing officer starts questioning Gabriela. Well, let me ask you about your J1 visa application. And Gabriela is not even worried about that because she doesn't even remember what happened at her J1 application. It turns out that on her J1 application, she submitted it herself, and there were a few questions regarding her student status in Romania. Okay, so at the time when Gabriela obtained the J1 visa, she was the last year or fourth year in her education and her pursuit for a bachelor's degree. She submitted documents to show that she's a student, and one of these documents is a statement or evidence from her university of her student status and the year she was particularly in at the time or close to the time of the interview at the American Embassy. And even though Gabriela was a fourth-year student who was supposed to graduate on or before the day of the interview, she presented a document that stated that she was in fact a third-year student. Why did she present this document? Maybe the agency who handled her paperwork or the agency who sponsored the program advised her so. I don't really know. But at the end of the day, she indicated that she was a third-year student when she was in fact a fourth-year student. And as most of us immigration lawyers know, it's harder to obtain a J1 visa, which is a summer work and travel visa, when you're in your fourth year of education. Why? Because you're done with your education, and the chance that you're going to go back to your home country are less than the chances to go back if you're actually in your third year. Why? Because if you're in your third year, you want to go back so you can continue your education. So the immigration officer reviewed her application for a J1 visa and determined that she actually misrepresented her student status, and specifically the year she was the year she was supposed to graduate. So because of this misrepresentation that the officer deemed material, the officer advised Gabriela that her application for adjustment of status, or in short, green card, will be denied. Why? Because she procured the J1 visa by misrepresenting her status at the time of the J1 interview at the American Embassy in Romania. Okay, so what do we do next? Now, Gabriela finally realizes that she needs an attorney. Why? Because her green card was just denied. Well, she needs an attorney because she will have to file what is called a fraud waiver or a misrepresentation waiver. With that application, the applicant, Gabriela, has to prove that her husband, Michael, will suffer an extreme hardship that goes beyond what other couples would suffer if Gabriela has to go back to Romania, or two, if Gabriela and Michael have to move to Romania and live there. So Gabriela has to prove hardships both ways, that Michael will suffer if he remains in the United States, and then he'll suffer again extremely if they have to move and live in Romania. How do you prove hardship? Well, if you want to find out, my best piece of advice is to consult with an immigration lawyer, because there are many factors that are usually reviewed and considered when someone files an application for a fraud or a misrepresentation waiver. These waivers are very hard to get because the US government pretty much has to forgive you for the fraud or for the misrepresentation you made. And it's a two-step process. You have to prove that your spouse or other qualifying relative is going to suffer the extreme hardship. And it's hard to prove the hardship when the couple is still together, because you have to prove that your spouse or qualifying relative will suffer the extreme hardship if this and this happens, if Gabriela is deported to Romania, or if they both move to Romania. So we're talking about the future. And the other scenario is you have to prove the same hardship that goes beyond what other couples would suffer if Michael remains in the States and Gabriela goes back to Romania. And then once you prove the hardship, you have to prove another element, another requirement, that the USCIS should grant your waiver application as a matter of discretion. In other words, are you a good person? Do you deserve discretion exercised by USCIS? And there are a lot of factors involved in proving that particular prong of the hardship test or the waiver test. So if you're in a situation where USCIS has alleged that you have engaged into material misrepresentation, or in other words, fraud, your best bet is to consult with an immigration lawyer and see whether you have sufficient facts that would warrant filing of a hardship waiver. It's called a 601 fraud or a misrepresentation waiver. You still have a chance to obtain the green card. You just have to get the waiver approved So then the government forgives you for the misrepresentation, and then you're again eligible to obtain a green card.